So I see there are about 20 participants, and welcome to all of you, especially to Dr. Fiskatoris, who is our speaker today. My apologies for not joining you in person. I don't know how many there are in person, and if you are a majority or whether we who are online are a majority. But just a few words from me. You will know, most of you, that the African Center for Transnational Criminal Justice was re-established in 2020, and it follows upon the former South African German Center for Transnational Criminal Justice, which was a partnership between the University of the Western Cape, Humboldt University, and the DART program, or the Deutsche Akademische Austauschdienst, from 2009 to 2018. Now, the African Center for Transnational Criminal Justice, its vision or its goal is to be a leading research center, locally and internationally recognized as the intellectual hub of transnational criminal justice in Africa, and to drive the African agenda through excellence in research, postgraduate training, and engagement with contemporary regional and international challenges. We know that these challenges today are huge, thinking of the continuing war in the Ukraine, the wars and conflict in many African countries, including South Africa, which has very high levels of crime, and these often have an international flavor. And we hope that the center can play an important role in finding solutions to these challenges. The center is, over its past 2-3 years of existence, it has grown significantly, both in respect of staff numbers and also postgraduate students, for which we are very glad. Its offices are currently being renovated, and we hope that we can soon host international visitors there. We hope that Dr. Fiskatoris can come soon, and that we will also be able to host seminars there in the boardroom. Now, Dr. Fiskatoris, who's our speaker today, he was appointed in May 2022 as a research fellow of the center. He's also an adjunct lecturer at the university, the Philipps University of Marburg in Germany. And his research focus, as you will have seen, is very interesting because he looks at the doctrinal and historical foundations of international law. So finally, again, welcome to the seminar. I look forward to hearing Dr. Fiskatoris. I hope we can hear him. But I may not be able to stay until the end, but thank you very much.
Thank you.
Thank you. Without wasting any more time, myself, Stephens, you may start with your presentation.
Sorry, I didn't hear you very well, but I think I may start with my presentation. Is it true?
Yes.
Okay. Thank you very much, Dr. Nai. Thank you very much, Professor Deville, for your kind introduction. I am Taxiarchis Fiskatoris. I am a proud fellow of the African Center for Transnational Criminal Justice, and today I would like to discuss the historical evolution of international criminal justice. With the term international criminal justice, we can describe both the international and domestic prosecution of international crimes, but I will confine my presentation to the evolution of international penal mechanisms, to international criminal tribunals. I understand as international courts and tribunals those that have either been established by an international treaty or which are composed by international judges. I also should note from the outset that I make a distinction between the development of international criminal justice and the development of international criminal law. I am only going to talk about the first part, which is the easier, the development of international criminal justice, because the development of international criminal law is a much broader and complex topic. You may have read in textbooks of international criminal law about how international criminal law evolved out of customary and conventional rules of international law of armed conflicts and international humanitarian law. You've heard perhaps also of piracy being the original international crime, in the sense that the so-called principle of universal jurisdiction has been applied to this offense since the time of the Roman Empire. But there has never been an international penal mechanism to prosecute pirates. Although the rhetoric of assimilating war criminals to pirates in a way legalized, in the eyes of the public opinion, the establishment of the post-World War II international military tribunals. Now, for most scholars, the Nuremberg and Tokyo tribunals are the birthplaces of international criminal justice. And there is no doubt that Nuremberg and Tokyo were significant turning points in the history of international criminal justice. Nevertheless, we should not underestimate early proposals and early efforts and drafts that preceded Nuremberg and Tokyo. And in my opinion, we should not exclude from historical narratives ancient and medieval international penal tribunals just because they do not fit into our modern Westphalian understanding of international law. Unfortunately, most international criminal law and criminal justice textbooks tend to relegate the significance of early instances of international criminal justice and focus on the road from Nuremberg to Rome, from the Nuremberg trials, then to the ad hoc tribunals for the former Yugoslavia and Rwanda, and then to the establishment of the International Criminal Court. I'll do my best today to deviate as much as my personal knowledge allows me from this traditional narrative. But of course, my knowledge on the matter is limited, circumscribed by my own education and readings, and I would be extremely happy to hear from you during the discussion about your own thoughts on what should be included in discussions on the history of international criminal justice. If I may share a PowerPoint with you. Okay, I see that you can see my PowerPoint, but I don't know why it doesn't get bigger. Okay. Is it better now?
Yes.
Okay. So, in my opinion, and once again, under the disclaimer that I haven't read the history of every nation in the world, the first ever international criminal tribunal in history took place in the year 405 before Christ in ancient Greece. It has been established that ancient civilizations did have mostly unwritten but also written rules about what was and what was not allowed in times of war. It may be debated whether we can classify those ancient customs as international law, but such discussion goes beyond my presentation. So for those violating the rules, for war criminals of ancient civilization, there was no trial, but usually instant death when they counted among the losers of the war. And as you may readily guess, there was usually impunity when the perpetrators had won the war. Now, ancient Greece, as you can see on the map I'm sharing, was separated in independent city-states. Every city was a different state with its own territory, government, economy, army, and domestic rules. But there were also customary rules that commonly applied to all Greek city-states, an ancient form of international customary international law. Such customary rules were, for instance, the rules that the bodies of the dead soldiers were sacred and should at all instances be respected. It was also considered wrong to cut off the enemy's water supplies or to make use of poisoned weapons. Now, in 405 before Christ, there was a war between two major cities, Athens and Sparta, and their allies. Long story short, Spartans and their allies captured most of the Athenian fleet at a place that today is known as the Turkish Straits, up there where I have marked it with a red circle. Now, once the victory was secured, the Spartan leader brought all prisoners to a town there called Lampsakos. And among the leaders, there were also the generals of Athens. And all we have about this first indication of an international criminal tribunal is a small extract from an ancient historian called Xenophon. So, according to Xenophon, Lysander, the leader of the Spartans, gathered the allies, the independent city-states, together and told them to decide about the fate of the prisoners of war. In that discussion, many accusations were made against the Athenians, both the many deeds they had done that were contrary to law and the many resolutions they had passed concerning what they would do to their enemies had they won the battle, in particular to cut off the right hands of those they captured. It was also noted that the Athenians, when they had captured Spartan allies' ships, had thrown all the men on those ships overboard. Many other accusations were made, and finally it was decided to kill all the prisoners except one general who had opposed the decree about cutting off hands. So we actually don't have the time to analyze it in every detail, but this seems to be the first ever international criminal prosecution that ever took place. But this is not the one that most textbooks on international criminal law present as the first international criminal trial. That would be the trial of Peter von Hagenbach in 1474. According to the most popular view, the history of international criminal justice begins in medieval Germany, a town called Breisgau or Breisach today, where there was a ruler called Peter von Hagenbach, a knight, who was serving the Dutch of Burgundy, which is what you see in yellow color. So the region of Alsace, where Breisach is located, was occupied by the Dutch of Burgundy. And Peter von Hagenbach, the local governor, was accused that he ordered or allowed his troops to rape and kill innocent civilians and to pillage their property during the occupation, of course. Several independent city-states, once again, of what was back then the Holy Roman Empire, an early German empire, including, for instance, Austria, Bohemia, Luxembourg, but also Milan, the Italian city in Switzerland. All these allied cities sent judges to judge Peter von Hagenbach, and they found him guilty of crimes against, I quote, the laws of God and man. They stripped him of his knighthood and sentenced him to death. The reason why this is considered by most us the very first International Criminal Tribunal is that a British jurist called Georg Schwarzenberger, an early pioneer of international criminal law, had published an article while the Nuremberg trials were still taking place, and so the American prosecutor of one of the subsequent Nuremberg trials cited Schwarzenberger and the trial of Peter von Hagenbach to show and to prove that crimes against humanity was not a novelty, but something that had already been punished in the past. Now, the next trace of not really criminal, but quasi-penal jurisdictions that we meet in the history took place during the 19th century. Having proscribed its own participation in the slave trade in 1807, Great Britain embarked on an ambitious campaign, international campaign, to halt the slave trade globally. And this led to the first mechanisms for extraterritorial adjudication in modern history. Between 1817 and 1871, a series of bilateral treaties concluded by Great Britain with Portugal, Spain, the Netherlands, Brazil, the United States, and several states at the coast of the Atlantic Ocean, including several newly independent Latin American states. These bilateral treaties created mixed commission courts, arbitration courts. They did not intend to punish themselves as tribunals, slave traders, but in all of these treaties, there was a provision that the parties were empowered to destroy or confiscate slave trade vessels, and they were under an obligation to punish the slave traders under their own jurisdictions. Now, during the second part of the 19th century, there was a major war in Europe between the Prussian and the French empires. The Prussians, the Germans, actually won, and the French Emperor Napoleon III was apprehended, and the German Chancellor Otto von Bismarck conceived the idea of a court composed of judges from the great powers to prosecute the French Emperor. This never happened, but 2 years later, one of the co-founders of the Red Crescent movement, alongside Henri Dunant, his name was Gustave Moynier. He also envisaged permanent international criminal court. This was the first time that someone thought of a permanent criminal tribunal with the jurisdiction to prosecute violations of the first Geneva Convention for the amelioration of the condition of the wounded in armies in the field, the first ever convention of what we now know as international humanitarian law. That court would not have a permanent seat, but it would have automatic jurisdiction when a war started between parties to that, to the constitutive treaty of the court. It was something like an arbitration tribunal. The judges would be appointed by belligerents, and there would also be neutral judges on the bench. The procedure would not be predefined but agreed by the judges. Only states and not individuals could initiate proceedings. Interestingly, victims would be entitled to compensation, but there was the problem of penalties, which Moynier did not touch upon. He left that for another treaty. Actually, his idea, this vision, was never realized. Nevertheless, it's still the first ever draft in history for a permanent international criminal court. It was not until after the First World War that the provision for the creation of an international criminal court was inserted in a multilateral treaty. The proposal came only a few days after the armistice in Europe by the French Prime Minister Georges Clemenceau. And following lengthy deliberations at the Paris Peace Conference that ended the First World War, Article 227 of the Treaty of Versailles provided for the creation of an international special tribunal consisting of 5 judges from the winners, Britain, the US, Japan, France, and Italy, to prosecute the German Emperor, Kaiser William II, for a supreme offense against international morality and the sanctity of treaties. Above all, it would be a court for aggressively invading Belgium and instigating unrestricted submarine warfare. The Treaty of Versailles further provided for the prosecution of other war criminals by domestic courts, either in Germany or in other states that took part in the First World War. But in the end, the German Emperor William II evaded justice and lived happily ever after as a guest of the Dutch government, and only very few minor perpetrators were convicted at the Leipzig trials in Germany and the Istanbul trials in the Ottoman Empire. Yes? Yes. So, to give you an example, at Leipzig, out of 900 defendants, 888 were acquitted, and the rest actually were allowed to escape. But even the perpetrators, the Ottoman perpetrators of what is known as the Armenian genocide, were never really prosecuted. Now, one often forgotten aspect of this first attempt of international criminal justice after the First World War was the absence of any action regarding African suffering during or shortly before the Great War. As a matter of fact, and this is not very not a very well-known fact, atrocities in Africa were investigated by the British, and they were included in 2 so-called blue books. The second of them was almost exclusively devoted to the German massacres against the Herero and Nama in what is now Namibia. Nevertheless, for obvious reasons, the British decided not to include, not to charge any German war criminals for atrocities in Africa, but only for war crimes in Europe. Now, the provisions of the Paris Peace Treaties inspired legal scholars, and so during the interwar period, there have been several new proposals for permanent international criminal courts, either by academic bodies and NGOs, such as the International Law Association or the International Association of Penal Law. Both of them are still very active, and within those associations, we can identify some pioneers of international criminal justice, such as the American Hugh Bellot or the Romanian Vespasian Pella, who themselves drafted statutes for a proposed permanent international criminal court. As a matter of fact, there was also an effort within, under the auspices of the newly created organization by the Treaty of Versailles, the League of Nations. So the Advisory Committee of Jurists, what is now known as the International Law Commission, was entasked to establish what later became the Permanent Court of International Justice, the predecessor of the International Court of Justice in The Hague. The head of the of the Advisory Committee of Jurists, Edward Descamps, of Belgian origin, had the idea of creating not only a court of interstate dispute resolution, but also advocating to this, giving to this court the possibility to conduct criminal trials. Something very much alike with what I'm sure that most of you know, the Malabo Protocol intends to do with regard to the African Court of Justice and Human and People's Rights. So this idea of the Malabo Protocol is not as modern as we may think, but there was a similar idea in 1920 of a court, of an interstate court, and at the same time an international criminal court. But nothing happened until political circumstances would generate interest in a permanent international criminal court and would lead to the first ever multilateral treaty providing for a permanent international criminal court. So we had a draft, a first idea by Moynier. Then we had in the Treaty of Versailles the idea of an ad hoc court against the Kaiser. And in the 1930s, we have a treaty that provided, a treaty that was adopted under the auspices of the League of Nations and provided for a permanent international criminal court. But that court was not about war criminals. It had nothing to do with war crimes, crimes against humanity, genocide, what is they known as core crimes, but it had exclusively to do with the crime of international terrorism. And this treaty was possible after the assassination of King Alexander of Yugoslavia and the French Foreign Minister Louis Barthou, whom we see on the picture I have, on the photo I have here. They were assassinated by a terrorist group on French soil. Then they evaded justice. They went to Italy. Italy wouldn't extradite them. So the French proposed a court that would serve as the third avenue to the principle of aut dedere aut judicare. In other words, a court that would serve as an alternative when a state like Italy wouldn't like to prosecute the offenders of international terrorism for political reasons, but wouldn't also like to extradite them to another state. So this court was presented as a third neutral alternative. And in 1935, the League of Nations started a procedure by establishing a committee to create such a court. That committee initially prepared one draft convention, but then this one draft became two different international conventions. One international convention against terrorism, which is the only treaty convention in history that defines terrorism, and a parallel one with a tribunal which would deal with the terrorism offenses defined in the twin convention. They created two conventions to make it possible for states to ratify just one of them. These two conventions gathered several signatures, but unfortunately, at least the one about a permanent international criminal court, only one ratification coming from India. But nothing happened later mostly because the Second World War started. There were other reasons as well. For instance, the opposition of the British. I don't know how much time I have left because I don't have an eye on any clock. So if I must move faster, please tell me. Okay, so the Second World War started, and now we come to something more well-known, the Nuremberg and Tokyo trials. The British Casey Geoffrey Robertson has explained in plain words how the establishment of the Nuremberg Tribunal was possible. I quote, Churchill wanted to give the captured Nazi leaders 6 hours to say their prayers before putting them in front of a firing squad. Truman, the American president, responded that this course would not sit easily on the American conscience. The deadlock was broken by the third ally, Joseph Stalin, loved short trials as long as everyone was shot at the end. So this was the idea behind the Nuremberg Tribunal. And its twin in the Far East, the Tokyo Tribunal. But since these two military tribunals, the details of those tribunals are pretty much well known, I want to focus on something, on the commission that made the establishment of those tribunals possible. And I refer to the United Nations War Crimes Commission, which was responsible even before the end of the Second World War. Since 1943, it was responsible to investigate war crimes, to collect evidence, to identify war criminals, to find the legal basis for punishment, which crimes were going to be prosecuted, and to prepare indictments. The only thing that this commission did not have was the power to prosecute itself. It had to create, to draft the constitutive instrument of an international tribunal, what later, after the Moscow Declaration, became the London Charter of the Nuremberg Tribunal. Now, in that commission, there were 17 allied nations that fought Germans represented, including South Africa and Ethiopia. And I wanted to mention that because the contribution of African states, of those 2 African states at least, to the United Nations War Crime Commission is under-researched. And that could probably be of a matter of interest. Perhaps you would like to write a thesis on such topics on the history of international criminal justice, and I would be very glad to supervise such thesis. Now, South Africa, from what I've read, didn't contribute too much and definitely did not hold national trials. But Ethiopia really tried to hold the Italian fascists accountable for the massacres they committed during the so-called Italo-Abyssinian War, the invasion of Ethiopia in 1935, and the atrocities that followed the invasion. But the Commission, the United Nations War Crimes Commission, once again did not include crimes perpetrated against Africans. And the pretext presented to ignore the crimes committed against Ethiopia was the lame argument that the Italian war on Ethiopia took place before the beginning of the Second World War. And this argument was not tenable because it showed inconsistency of policy by the Commission, which considered charges submitted by China for crimes perpetrated by the Japanese against the Chinese before the commencement of the Italian war on Ethiopia. The Japanese invasion of Manchuria took place in 1931. The Italian invasion of Ethiopia in 1935, but still no prosecution of Italians. Okay, now in 1948, the Genocide Convention was adopted, and in its 6th article, it envisaged the establishment of international penal prosecution for the penal jurisdiction for the prosecution of the crime of genocide. At the same time, the International Law Commission of the newly established United Nations Organization started discussing the matter of the desirability and possibility of establishing an international criminal court. And it actually provided a draft statute in 1951 and a revised statute in 1953. Actually, the Commission started drafting those texts, but the final drafts were the outcome of a political body, an ad hoc committee that was created for that reason. The next important checkpoint in history is the Apartheid Convention in 1973, which in its preamble and first article declared apartheid as a crime against humanity. And more importantly for our topic today, the Apartheid Convention in its fifth article replicated the Genocide Convention, providing for an international penal tribunal. This time, the United Nations went one step further, and in 1980, the ad hoc working group of experts on Southern Africa started the study on the establishment of the international jurisdiction envisaged by the convention, and commissioned Sheriff Bassiouni, a very well-known pioneer of international criminal justice, to come up with drafts establishing the tribunal that was provided by Article 5 of the Apartheid Convention. And Sheriff Bassiouni indeed came up with two ideas. The first one being the creation by means of a protocol of a court-like institution to exclusively adjudicate violations of the Apartheid Convention. But he went one step further and he proposed in the alternative an international criminal tribunal, not only for the crime of apartheid, but for other international crimes as well. You know, these projects were never realized, although they inspired NGOs to come up with new drafts that took into consideration the views of the new independent countries that were created after the decolonization process. But there was, you know, also an unforeseen, perhaps bad, I would say, development. You know, during the 1970s, within the African Union, there was a discussion, the first discussions about an African criminal court. One of the reasons that those discussions within the African Union stopped at the time and re-emerged many, many years later was that African states were expecting much from these projects based on the Apartheid Convention. So one of the arguments heard within the African Union organs was that it's still premature to talk about an African court. After all, there are projects based on the Apartheid Convention to create such a court globally already. So why do it now regionally? Coming closer to the end, the road that led to Rome, I mean the final phase before the establishment of the International Criminal Court, did not start in 1993, when the ad hoc criminal tribunal for the former Yugoslavia was created, but in 1989. And a new impetus was created by a proposal coming by the Prime Minister of a Caribbean state, Trinidad and Tobago. The name of that pioneer of international criminal justice was Arthur Robinson, who achieved to make the United Nations General Assembly to reinsert the question of an international criminal tribunal into the agenda of the United Nations organization. Funny thing, once again, like the tribunal about terrorism, it was not one of the so-called core crimes that instigated the new impetus on the International Criminal Court, but international drug-related offenses, international drug trafficking, one of those offenses that are nowadays relegated by most scholars as transnational crimes and not of the same nature as core crimes. The International Law Commission created a working group chaired by Professor Abdul Koroma from Sierra Leone. He also served as a judge at the International Court of Justice. And that draft statute of 1992 included several crimes that do not appear nowadays in the Rome Statute of International Criminal Court, such as intervention, colonial domination, and other forms of alien domination, apartheid, recruitment, use, financing, and training of mercenaries, terrorism, trafficking, narcotic drugs, and severe damage to the environment. All those offenses disappeared from subsequent drafts, and after the ad hoc criminal tribunals for the former Yugoslavia and Rwanda, I argue in a chapter that I've written that the ad hoc tribunals gave the opportunity to the global north to halt the dynamic of the dynamic that international criminal justice had gained to become a truly counter-hegemonic project. So definitely the ad hoc tribunals for the former Yugoslavia and Rwanda were the first instances of an international tribunal after Nuremberg that really prosecuted war criminals or genocidaires, perpetrators of genocide. But on the other hand, they allowed the global north to own back a project that was driven by the global south during the Cold War period. After all, one may ask themselves if a tribunal for the atrocities in Yugoslavia, why not a tribunal for atrocities that were committed during the African and Southeast Asian wars of independence? For instance, the atrocities, the British atrocities during the Mau Mau uprising in Kenya. These are legitimate questions. Anyway, in 1998, a conference was summoned in the Italian capital for the establishment of the International Criminal Court, the way we know it today. Once again, representatives of the Global South had a disadvantage because of the special proceedings within that conference. The delegations, for instance, of several African states were so small that they couldn't attend all the committees, drafting committees that were taking place at the same time. So the Global South had once again a disadvantage during the Rome conference, but no one can deny that having a permanent international criminal court is a huge step. It depends on the states whether we use this court, this instance that we have, to the benefit of all international community or to the benefit of the few major political powers. So thank you very much for your attention. I hope that I kept it within acceptable time limits. Thank you very much. Hello, can you still hear me?
Tracy, I think you guys are on mute.
Apologies. Thank you. Yeah, you can proceed.
Okay, can you hear me now?
Ralph, can you your answer now?
Can you hear me?
We can hear you, yes, Tracy.
No, I'm saying, could you your answer?
We couldn't hear answer now.
Yeah, just
Thank you. I was just saying thank you so much for the presentation, and just to highlight other events pre Nuremberg that also contributed to the international criminal justice. So I would now first to open up any questions. Those who are online, you can make use of the chat room, and then I'll just read out the questions. And then if the audience on campus, they do also have some questions, and then they can also feel free. I will just move around the mic. So any questions, comments, clarity that is required for Dr. Fiskatoris?
Thank you very much, good afternoon, colleagues. Thank you very much, Dr. Fiskatoris, for your presentation. I think you situate the topic in its proper historical context. About the trajectory of international criminal justice and the norms and values that it protects. In the present situation, in relation to the Malabo Protocol, you did mention that certain African concerns were not properly reflected in the Rome Statutes. Looking at the substantive provisions of the Malabo Protocol and the Rome Statute of the ICC, and today, why, in your own opinion, do you think there is such variation in terms of specific crimes like terrorism, mercenaries, and other crimes that are included in the Malabo Protocol, but that the Rome Statutes obviously left out? Thank you.
Thank you for your question. Perhaps some more questions and I can reply all of them, or do you want me to just reply to each one?
Yeah, I think for now you can proceed to reply while we wait for more questions. Yeah.
Okay, so thank you very much for this question, and it is as a matter of fact, the question you posed was the question, the primary question of my PhD thesis, and I wrote a whole thesis on the topic why those crimes that many scholars call transnational crimes were not included in the Rome Statute of the International Criminal Court. It is a complex question, and there are several arguments which, at least in my thesis, I try to deconstruct. For instance, that transnational crimes are of a different nature from the so-called four-core crimes, that for instance, the crimes included in the Rome Statute are based on customary international law, but transnational crimes are based on treaty law. They are called treaty crimes, so they're not the same. There are also arguments that transnational crimes are of a lesser gravity, seriousness than other crimes. There is also a theory, and this is very prominent lately, the theory of direct criminalization of core crimes, whereas transnational crimes are only indirectly criminalized and not directly under international law, but through the mediation of domestic jurisdiction. So there are many arguments, and all of them can be deconstructed. Of course, I tried to do that in my PhD thesis, and my conclusion is that the exclusion of the so-called transnational crimes from the jurisdiction of the International Criminal Court was nothing but a political decision made by those major political powers who weren't prepared to give away their jurisdictional prerogatives. It was hard for major powers to deny giving to the International Criminal Court jurisdiction over offenses that they themselves had included in Nuremberg 50 years ago. Although they tried, aggression was not automatic, it did not automatically come under the jurisdiction of the International Criminal Court, although they had prosecuted crimes against peace in Nuremberg. But they weren't prepared to include in the Rome Statute crimes that were of particular interest to African states and generally to states from the global south. As we see, Trinidad and Tobago, a Caribbean state, wanted a court mostly about drug trafficking, because Trinidad and Tobago and Caribbean states are affected by this transnational crime. In other words, major powers wanted a court to punish the unwilling when the global south, or most of it, wanted a court that would come to assist the unable, or at least those with difficulties. So there were two different visions. So in my opinion, this was purely a political decisions, and all legal arguments can be deconstructed.
Thank you so much, Dr. Fiskatoris. There is one question in the audience. Just give us a moment.
Thank you. Doctor, thank you so much for the lecture and for starting the history of international criminal justice. Just for going there even further. So the question I have for you is, as an expert in international criminal justice, the International Criminal Court recently issued out a warrant of arrest against the Russian president, Vladimir Putin, and is due to have a visit here in South Africa. So my question is, how would you advise the South African government to sort of navigate this situation? Because South Africa is a signatory to the Rome Statute, which means that advised to arrest president of Russia. But what would your advice be, even that to any other country besides South Africa that is a signatory to the Rome Statute that has a similar situation to the one that we have now? Thank you.
Well, once again, because it happened before, the hot potato is in the hands of the South African government, because it happened also with al-Bashir from Sudan that visited South Africa, and South Africa did not apprehend as it ought to under its international conventional obligations and its domestic laws, as, if I'm not wrong, you're better aware about that, the South African courts have decided. So I believe that it is a conventional obligation under at least the Rome Statute, where South Africa is still a party, to apprehend any person that is indicted by the International Criminal Court. I couldn't advise otherwise. I am an idealist and a fervent supporter of public international law, but I understand politics. Well, yes.
Yeah, okay, thank you so much. There's also one question from the online audience, and the question is, if I may ask, would you advise a student who wishes to do a research thesis on the development of ICJ to tackle various treaties and tribunals that contributed to the development of ICJ, or rather focus on one or two?
Well, one can do both. It depends on how we formulate our research question. Of course, a thesis cannot be huge, so one easy solution would be to focus on one or two tribunals, a comparative study, or on a couple of tribunals that have things in common. But one can also research the whole development, the whole historical evolution of international criminal justice, if they pose the right question. For instance, what has been, just give you an example. Of course, you can find a topic and then examine it through the history of international criminal justice. I chose the topic of transnational crimes. You can choose a different topic and look and research it from a legal historical perspective. For instance, I researched the subject matter jurisdiction of international criminal tribunals. You can research the jurisdiction ratione persone of international criminal tribunals. For instance, we know that the Malabo Protocol cannot only prosecute individuals, but also corporations for the perpetration of international crimes. So one interesting question would be, what did all those drafts in the history of international criminal justice say about international corporate accountability? I just give you an example, and so my answer is that you can do both, as well as you confine your research and you pose a clear and researchable research question.
Well, thank you so much for that. I'm sure that provides much more clarity. There is also another question. So the question goes, you mentioned the contributions of Gaston in the development of ICJ. Given the fact that he was of Red Cross, what role did civil society organizations play in the evolution of international criminal justice?
Thank you. You just gave yourself a very good research question for a thesis or anything. I mean, I skipped most of the slides I had about NGOs that drafted statutes for international criminal tribunals. And in my research, I have also read most of the reports of NGOs during the preparatory works of International Criminal Court. There is too much to be said there. Many different positions by the NGOs about many different topics. So we can't say that NGOs have a common position on all matters. They actually prioritize their interests over other things. I can here from my research, I can follow up with my previous answer and say that NGOs did not really support the inclusions of transnational crimes into the jurisdiction of the International Criminal Court. You may ask yourselves, but why? And the answer is simply because they prioritized the other factors of and other advantages of creating an International Criminal Court at this time and not just leave it for later or never. There were NGOs that promoted gender-related crimes and other NGOs that were against the inclusion of such crimes. So there are many things that you can research there about the role NGOs play in the development of international criminal justice, and not only at the final stages, but also during previous and early drafts of international criminal justice. Arthur Robinson, who made the Prime Minister of Trinidad and Tobago, who made the 1989 proposal, was actually an executive director of an NGO promoting international criminal justice. And when he became Prime Minister, he promoted this idea of that NGO, and he did it. So many things to research there.
Thank you. One actually wishes to inquire whether you'll be able to share your slides, if possible.
Definitely. I will send them to you, Tracy, and then you can send an email or whatever.
All right, thank you so much. It appears there aren't any more questions, so I would hand over to Paul. Oh, actually, there is one more question that actually came through. What is the difference between ICJ and ICL?
So I made my introduction distinguishing international criminal law from international criminal justice. When we refer to justice, we refer to mechanisms that either directly or indirectly enforce international criminal law. International criminal law is a much broader concept. It contains substantive rules, it contains procedural rules, it contains many things, but international criminal justice is only about the enforcement mechanisms. International criminal justice, I said, is mostly about international penal tribunals. But you know, international criminal law is not primarily enforced by international criminal tribunals, but by domestic tribunals, right? So international criminal law is not only a matter of international criminal justice, it's also a matter of domestic criminal justice. We should always separate before the two, and as I mentioned at the beginning, international criminal law rules started developing from the very early societies, not only civilizations, but the very early societies existing on the earth, whereas international criminal justice started centuries later, and I would say advanced not that quite rapidly as international criminal law did.
Well, thank you so much. I do actually have one question. So you did indicate that mostly when we speak of justice, this is reflective of mechanisms, and there is a I would say, discussions on the decolonization of international criminal justice. So I just wanted to poke your thoughts on such issues, or if you have any comment on that.
It's allow me to to reserve my comments. I feel that I'm not the best person to talk about to answer this question. I know that among us there are experts, and in the African Center of International Criminal Justice, there are many experts which have very much deeper knowledge than me on the topic of decolonization. So if you allow me, just for today, I will reserve my comments. Out of respect.
Yes, there is just one more question.
Good day, Fiskatoris. I just have one question in relation to the Malabo process code. Right. So it's in relation to the jurisdictional aspect. So we have the ICC, and now I know the Malabo protocol is not yet enforced, but also how will that work? Because I know that some of the core crimes that are in the Rome Statute also appear in the Malabo protocol. Can you hear me? Am I audible? Oh, so I know that some of the core crimes that are in the Rome Statute are also appear in the Malabo protocol. So I want to ask, will this work in conjunction with the ICC, or will the Malabo protocol be subsidiary to the ICC? So how will the jurisdictional aspect work?
Thank you for your question. Yes, look, first of all, we can notice that there are slight differences between the definitions of core crimes in the Rome Statute and in the Malabo Protocol. They may seem insignificant at first glance, but they are very significant. I mean, even if we just add a word to a definition, we actually may make that definition broader or narrower. So the definitions in those two, in the Rome Statute, do not 100% coincide with the definitions in the Malabo Protocol, and that could be a problem. But generally speaking, there is nothing in the Rome Statute impeding what we could call regional complementarity. As a matter of fact, the International Criminal Court was meant to be a court of last instance, a court complementing domestic jurisdictions. So why not just complement regional jurisdictions? There is no collision there. I believe, yes, as far as the core crimes are concerned, that they should first be dealt with by domestic jurisdictions, and if that's not possible, then by the global court, the ICC, in order to avoid tensions. But if the International Criminal Court continues being so selective as it is today, I see no reason why not creating regional courts dealing better with matters of special interest to specific regions, including Africa.
Thank you so much, Dr. Fiskatoris. It appears there aren't any more questions. So once again, thank you for taking us through the historical development of ICJ and also highlighting, the politics involved as well. So without wasting any more time, I would like to call on Professor John Mark-E for his closing remarks.
Thank you very much, Dr. Fiskatoris, for your excellent presentation. I enjoyed it thoroughly and learned a lot. And I'm very sure that the audience and colleagues here also learned a lot from the presentation. And just to mention, I hope the students who are here, we are taking notes, and you can pass the word around. Those who were not here probably missed out on a lot of things. I'm sure, like Dr. Fiskatoris indicated, you will leave here with at least one or two topics for your research paper or your seminar presentation or your mini thesis. Is it the issue of decolonization and international criminal justice project, or is it the question of the enforcement of the arrest warrant for al-Bashir, and a whole lot of topics that you can generate from today's presentation. It's the essence of this kind of presentation, to intellectually stimulate our thinking. And talking about current development, I will encourage you to watch at the space. We have two major events coming, and the one is in relation to transnational crime, particularly corruption and drug trafficking, which we'll be hosting sometime in April. It's actually going to be a book discussion on one recent publication. And the second, which will be one of our major events, will take place either in late April or in the first 2 weeks of May. We will send out the seminar and invitation and flyers. The second event is to discuss the arrest warrant for the Russian President Vladimir Putin. So we're trying to assemble a panel of experts to discuss the matter and look at what options are available and the legal implications for South Africa and how to enforce those, execute the obligations. So I thank you very much, everyone, for those who joined us online and those who made it to campus. We will now proceed to light refreshment. And once again, thank you to Dr. Fiskatoris. We are looking forward to having you over here in Cape Town sometime very soon.
Thank you very much, Professor, for this opportunity to be among you.
Thank you. So thank you, ladies and gentlemen, you can join us in the lounge for coffee. Okay.
Goodbye from me.
Bye.
Bye, everyone online. Thank you for joining.
Oh, my email is